Well, good morning to both of you. Today's date is February 1st, 2022, and we are scheduled for two oral arguments this morning. Yours is the first. It's State of Ohio versus Matthew Pajestka, 21CA0012M. As you can tell, joining me on the panel is Judge Carr and Judge Callahan. I'll be presiding today. Each party will have 15 minutes to present your argument. The appellant, of course, may reserve up to 5 minutes for rebuttal. So if you do want to reserve time, let me know before you get started, and we'll keep track of that for you. The argument is being visually and audibly recorded. We're live streaming on our YouTube channel, and so please mute your microphones when you are not arguing so as to minimize any distractions that we might have. It's not applicable in this case, but for those watching and for attorneys in the future who may be appearing before us, the court always cautions that we do not use the name of victims or minors in oral arguments. Counsel, we've read the briefs and we're prepared to proceed if you are.
Yes, Your Honor.
1 second. Give me 1 second, Ayrton. Okay.
All right, thank you, Your Honor. Joseph Patatus on behalf of Appellant Matthew Pajestka. I'd like to reserve, even though I don't believe it would be necessary, but the 5 minutes available to him.
All right, thank you.
Thank you, Your Honors. Going through here, we do have 4 assignments of error, and just going through them in order. I know the court, having argued in front of you many times, has, as you've already said, read the briefs and know the facts. The first issue is the exclusion of the appellant's expert, and I think it's, especially in light of COVID and how courts are handling jury selection, I think it's important to have clarity on this issue, because this is an issue that is unique. Medina Municipal Court historically held jury selection on the same day as jury trial. However, during COVID, the court bifurcated, rightfully. I mean, it's a common sense approach to bifurcate and have jury selection on day one. So everybody's spread out into 2 panels. You have a morning panel and the afternoon panel. And then on day 2, actually begin the actual hearing of evidence, the swearing in of the jury, opening statements, which is typically when we think of, or at least I should say, I won't say we, I think of a trial starting is on the day in which you're giving opening statements. That's the first day of trial. Here, the trial counsel below had submitted and attempted to comply with Rule 16, which indicates 20 days prior to trial that an expert report should be submitted to opposing counsel. When we count the 20 days, when I count the 20 days, I believe he filed it within the 20 days. However, I could see and can look at the argument that it was actually, he filed it on day 21, or served it rather on day 21. Day 21 being, it just depends on what day you pick as the start of trial. If you pick jury selection as the first day of trial, arguably it is day 21. If you pick it as the day opening statements were scheduled to begin, he timely filed it. But then from there has to be I think a prejudice analysis. And I think that's where all of our sister courts come out, is what was the prejudice to the other side? How was the other side actually impacted? And here the record shows that the prosecution already had their expert lined up. They had consulted with an expert. They had an expert prepared to testify. So it's not as if this wasn't a trial by ambush. This wasn't a sandbagging attempt. This was, it's not my practice. My practice is to have experts, 30, 45 days in advance, but trying to comply with the rule here, a young attorney, I think he lost his way between day 20 and day 21. But again, the prejudice to the other side, there was no prejudice to the other side. They consulted with an expert. They had an expert lined up from the Department of Health. So I would ask the court, and the expert here would have gone directly to essentially a third of basically half the case, the breath test. Would there have been it's material. Sorry, it's so I've been in my office for 2 weeks because one of my children had COVID and everyone's trying to hand me notes, so I do apologize for that. It was material. The expert here. This isn't a frivolous matter. This isn't a side matter. And then, though, the trial was continued. The trial was continued out several months. So the question then becomes, and I think this is where the trial court erred, just because an expert was excluded on trial one, a continuance should cure any prejudice that was given to the state, because that's our test, right? When we look at whether it's Lakewood versus Papadillas or Guadalupe, what's the remedy? Is it an exclusion is the most severe remedy? So it was excluded for the first trial, but exclusion only applied to that. Now, there was no basis to exclude it from the second trial because time had passed. And that gets us into the second trial, the exclusion of the doctor. There was essentially what we're arguing is there's no basis to exclude either the first or the second time. The next issue I wanted to touch on is going to be assignment of error number 3. I have the ticket up in front of me. And I know the ticket was transmitted as part of the record. It's my position, and I'm not saying this frivolously, but Mr. Pajestka was cited under 4511.92. And if you simply look at the numbers written on that line, the ones and the twos are very different. And this is
Counsel, was there a motion to amend the charging document?
There was never a motion to amend. This is a subject matter jurisdiction. When we talk about a charging document, whether it's a complaint or an indictment, both our case law and U.S. case law are clear on this. The defense can remain mute the entire trial. And if the state of Ohio fails to properly amend, and they have very, very liberal amendment rules in our state, you can amend prior to trial, during trial, for almost any reason. And I think here the court may have actually amended. I mean, if the evidence that this wasn't a second 20 years, that this wasn't a second refusal, I think the court may have amended it. However, there was never a motion made. And I believe when we look at the ticket, it's clearly 4511.19 A2A and then 4511.A2D. And when we just look at the numbers written in a row, the ones are distinct and then the twos are distinct as well. There was never a motion by the state who bears the burden. This is not plain error, and this is also not plain error analysis. Even though there was no objection made below, this is not a plain error matter. This is a subject matter jurisdiction. Did the court have subject matter over charges that essentially don't exist? So he went through trial. There was no evidence of a prior conviction. There was no evidence that he refused because he did in fact take a breath test. He blew a .093. So the prosecution moved forward on charges that either did not exist or were under the wrong code section. It was essentially be the same as trying a sex offense but convicting somebody of murder. You can't charge under two different code sections. And I'm getting a warning saying my connection's unstable. I don't know. Am I still being heard?
Yes.
You paused just for a very short time, but
Okay.
But you came right back on.
Okay. And then as our second assignment of error, and this is an important one because this is that thin line between the power of the kind of, you say, the righteous power of a prosecutor to use the overwhelming resources that the government has to prosecute someone. If an individual is undercharged in a case, for instance, let's say, I use my murder example. Let's say somebody's charged with felonious assault, but the victim died. A prosecutor is fully within their rights to say, plea is charged, plea to the indictment, or I'm going to bring murder charges against you. Completely proper. I would have no objection with that. That's the right and the power of a prosecutor to do that. However, when you get into constitutional rights, the power of the prosecutor must be curtailed. And here, as this court knows, Medina Municipal Court and the prosecutor's office is a no reduction jurisdiction as it comes to DUIs. So to look at what happened here, we have the start of a trial. The trial has commenced according to the prosecutor's argument because jury selection has commenced. That's the prosecutor's argument, just following their line of thinking. Jury selection is commenced, and the message from an officer of the court to another is, if your client testifies truthfully, he'll be prosecuted. That has absolutely nothing to do with plea negotiations. It's
Now,
not.
Counsel, let me stop you there, because you say the statement was, if he testifies truthfully, he'll be prosecuted. That's different than if he testifies and the elements of falsification are present, he'll be charged with falsification. Can you clarify that for us?
Absolutely. I think if the prosecutor said, if your client gets up there and lies, I'm going to have to charge him, but that's not what was said. If your client commits perjury, we're going to indict him on perjury. That's not what was said. It's simply not. We can't stretch the facts to go away from what was actually said. And the only evidence in the record is the affidavit of the attorney below, who filed an affidavit saying this is what was told to me. And we as attorneys have an obligation to report what is told to us to our clients. And here it's a line splitting, it's a hair splitting. What the testimony was going to be was that Matthew Pajestka was going to testify he had nothing to drink, quote, today. He was arrested at 12:30. He was going to testify that he had beverages consumed earlier the day prior with his family. And that was going to be the result of that was going to be his testimony. And I think the prosecution was scared, and they were worried that if that testimony came out, because it's consistent with the evidence, it's consistent with the dash cam, because he's clear today. I've not had anything to drink today.
I just need to interrupt you quickly to let you know you're at the 10-minute mark, so you're going to be into your rebuttal time when you continue here. Okay, go ahead.
I'll reserve the rest of my argument for rebuttal.
All right, you'll have 5 minutes. All right, hold on one second. All right, Attorney Philbin, are you prepared to proceed here?
Yes, I am. Thank you.
15 minutes.
Thanks. May it please the court, my name is Megan Philbin. I'm a prosecutor for the Township of Brunswick Hills, and I represent the appellee, the state of Ohio, in this appeal. Mr. Pajestka raised 4 issues. I'm going to just go through them in numerical order. So as to the first issue that was raised, it deals with the exclusion of his expert witness, and that being Dr. Robert Bellato. And as to the first issue, Mr. Pajestka had identified this expert to the state 20 days prior to the scheduled jury trial. And Criminal Rule 16 does require the disclosure 21 days prior to jury trial. I know there's some discussion that there was a mix-up on their part of, was the start of the jury trial on the first day when we start voir dire, or is it the second day when we finish voir dire, when we go into the presentation of evidence? State's position is it starts as soon as the voir dire begins. So that's the commencement of the jury trial, in our opinion. However, it wasn't just the fact that it was disclosed at that point for the very first time. It was actually served improperly on the state. And that was another issue that was raised. I just want to take a quick step back here too, that this was the first time the state had heard that Mr. Pajestka was interested in having an expert in this case. I know Mr. Pajestka had indicated that the state was already geared up to go with an expert witness. That is completely false. The state was not geared up with a witness. It was as soon as the state had received this information about the expert they wanted to call as a witness, that we consulted with someone from the Ohio State Highway Patrol and asked them if they were available. I had sent them the report that was given to us, but at that stage, there was no evaluation. There was nothing done by our expert. And so the state was not prepared for the jury trial to bring in our own expert yet. So that is incorrect. I also want to indicate that this case had a motion to suppress, and none of the issues that were raised in the motion to suppress signaled to the state that there would be an expert witness that would possibly be called. Also, the case had been set for trial 9 times, and an expert was never disclosed prior to those jury trial dates or bench trial dates. And so the state had no idea that this was coming. And so that's why the state had filed this motion in limine.
Counsel, is it your position then that the only date that ever counts is the date for the original trial? In other words, if the case is set, like you said, set 9 different times, um, uh, the defense can't raise the issue 21 days 21 days before trial on a second time or the third time or whatever, that it's automatically time barred because you didn't do it on the date of the first trial set.
Well, I believe that in this particular case, it was given the history of the case that it had been so old, that it had been set so many times. And it was very specific to this case itself, because this was a discovery sanction. I had filed a motion in limine, but the court had treated it as a discovery sanction to not allow them to use this expert. And going forward, there was, they attempted to disclose it later, but because it was a discovery sanction, the court said they were not going to permit them to bring the expert in. There was a motion to continue filed on the subsequent jury trial date because they were trying to allow this expert to testify. So the court had denied the motion to continue and noted that it was a discovery sanction. So I think it's very specific to this case. I don't know. I'm hard to say that it's a blanket statement for all cases. I don't believe that that's what it is. It's very specific to this case.
And so nobody's disagreeing that it was just basically 1 day, though.
I'm sorry, 1 day of.
It was out of rule by 1 day.
Well, that the state is disagreeing with that as well, because the service on the state was improper. So
Right.
Mr. Pajestka had emailed it to the state, and it was not received until I believe it was at least 3 days later, because they emailed a law clerk that is very part-time, and that's not something that we had ever identified to them in our filings was a way to serve us with anything. So it was improper service on the state, and we raised that as well. So that was one of the factors of why it was untimely. So as to that first issue, it's state's position, it was not abuse of discretion given the history of the case itself and the laws regarding disclosure. I think the trial court had thoroughly discussed and weighed what was presented to them by the state and by the defendant, and in determining that this was going to be a discovery sanction. So as to the next issue,
Before we do that, can we talk about the continuance and what effect, how we should handle that? The case was continued for 5 months, I think. So I suppose the argument would be that the state wasn't surprised at that point that the defense wanted to use an expert, and there was more than 21 days advance notice. What effect does the continuance of the trial and that 5-month delay have on this issue?
Well, I will say this, that in this particular trial court, this has been something that has been raised by defendants and by the state of Ohio, that if there's a continuance, this court has held that a discovery sanction carries over into subsequent trial dates. And so even if it was the state as well, it's happened to us too, that if we try to file for an expert on the next court date, it has carried over. So
how does that mesh with the rule that the least restrictive sanction should be applied by the court?
Well, it's my opinion that the court, thoroughly weighed that when they made their decision. I believe that it was a very thorough decision. It was, I think, at least 13 pages long, and the court considered that as well. So my position is it's not abuse of discretion.
Okay, thank you. I'll let you get on to your other arguments.
Okay, thank you. All right, so as to issue 2, this one is where Mr. Pajestka had filed a motion to dismiss. He raised it orally first concerning alleged prosecutorial misconduct and discovery violations. And so this comes up once the trial is in day 2. And I'm sorry, this comes up, well, it's raised on day 2, but the discussion that we're talking about happened on day 1 of the jury trial. So the parties had come in for the jury trial August 12th of 2020. And prior to the start of voir dire, parties were in the back and we were speaking with the judge in chambers, and it was Mr. Caro on behalf of Mr. Pajestka, was the attorney that was present, and it was myself as the prosecutor. And we were speaking about procedural issues. This was going to be the first jury trial that the Medina Municipal Court was going to have with COVID going on. So we were talking about different procedures, any issues with that. And the judge had asked us if we had exhausted all discussions about possible resolution. And we signaled to the judge that maybe we could talk a little bit more. So the judge encouraged us to do that. And we left the judge's chambers and went into a witness room in the back of the courthouse. So it was myself and Mr. Caro. And Mr. Caro asked for—
Counsel, I'm sorry to
Yes.
interrupt you, but you're, talking about something happened. Is that all that on the record?
Well, no, and that's
Well, then
that's
we
part
really
of—
can't consider that. I'm sorry.
Well, all I'm giving is a frame of reference that they make the argument that this was happening during the voir dire, during the jury trial, and that is absolutely incorrect. It's not
But
on the record.
how do
and
we
that's—
know that if there's nothing on the record?
Well, it's not on the record. It's the point of the state. It's not on the record. This is a discussion outside of the record, is what I'm indicating. So when they make the argument that it was occurring on the record or during the jury trial, it's not correct. So, so the parties have this—
But counsel, I think the suggestion, and I have not checked, but the suggestion is there is in fact an affidavit in the record, correct?
Yes, by Mr. Caro, that's correct.
Okay, so that's what we have to look at.
Yes, and if we take what Mr. Caro says as completely true, because I'm framing the context of where it was only because it was not on the record in front of the jury. He filed an affidavit after it wasn't a discussion on the record, is just the point that I'm trying to make here. So there was no discussion on the record of this issue. It was between the parties outside of the presence of Mr. Pajestka that these parties discuss possible resolution, and the state, we talk about exchange of discovery, things of like that nature. And the state identifies that what's in discovery, which he has not yet received because Mr. Caro had not gotten the videos himself, he didn't obtain them yet, was the statements that Mr. Pajestka makes concerning his alcohol consumption. So that's where all of this comes from. The state doesn't deny that there was a discussion. I mean, we discussed the issue of him testifying and changing his statements. And so that's where the whole discussion of any possible falsification or anything of that nature came up. And I think in Mr. Pajeska's motion, he indicates the state doesn't deny that we've had this discussion. There was no denial on my part. I admitted it from the onset. We discussed this issue. I was just merely warning him that if he committed a crime while he was testifying, that his client would be charged. So, and that's the basis of this discussion. So then the trial court permitted both parties to file briefs on the issue. And then they, excuse me, the trial court, again, thoroughly weighed the issues that were raised by Mr. Pajestka and the state, and found that there was no prosecutorial misconduct given what was relayed by both parties. As to that second
But there's
issue—
nothing under oath that was presented other than the affidavit.
I do not believe so, no, Your Honor. So the second issue that was raised by Mr. Pajestka was that there was some kind of discovery violation here as well. I don't believe he really goes in depth into that with what he filed. That was merely that the state had identified from the onset to all the attorneys. In this case, Mr. Pajestka had 3 attorneys. We identified the existence of these videos, and Mr. Caro had not yet gotten these videos, and he did obtain them. And he said that the state, they filed this motion to dismiss and said the state was withholding evidence. It's completely false because the state had identified these videos from the onset. In the record, there's also a motion to continue early on in the case that was filed by Attorney Sheldon, and that identified that very early on, prior to the motion to suppress, the state had disclosed the videos and he needed more time to go over them. So the court found that there was also no discovery violations with that.
Got
Moving
about
on
3
to the—
minutes. You've got
Thank
about
you,
3
Your Honor.
minutes left.
Thank you. Very quickly, moving on to the issue that, the third issue that was raised regarding the numerical designations on the citation. It is Mr. Attorney Patituch's position that the incorrect numbers are written in on this document. There was no incorrect numbers written in. It's just Mr. Patituch's interpretation of the numbers. If Mr. Pajestka had any question about what he was charged with, it was specifically written in there, but also there was a narrative description of these offenses that was right next to the numbers. So there was no question of what he was charged with. He had no confusion on that, and there was never an issue raised at the trial court level. He never identified to the prosecutor that, hey, I can't read this. And all the parties knew exactly what he was charged with, and we proceeded on that. Never raised any issue during the jury trial, never objected when the state was presenting evidence in this case. There was nothing, even when the jury instructions were read, he never objected to those offenses. And now he wants to say that those were not the offenses that he was charged with. These were the charges. It was the 45, 11, 19 A1A and the A1D were the two offenses that he was charged and convicted with. There was no question. And in issue 4, there is some question about whether or not the state could have presented this 1/3 of the HGN that was suppressed earlier on. This was also not objected to during the jury trial. And it's the state's position that because he failed to object to issue 3 and issue 4, that he should have raised a plain error argument, and Mr. Pajestka did not do that. And so it's the state's request that each issue in this case be denied, and so each assignment of error should be denied. Thank you, Your Honors.
All right, thank you very much for your argument as well. And you will have 5 minutes for rebuttal whenever you're ready.
Thank you, Your Honor. As it applies to issue number 3, the Supreme Court has already rejected the state's argument that Mr. Pajestka needed to do anything. That is State of Ohio versus Mobji. I apologize. It's in my brief on page 12. It's a 2011 case. It's a subject matter jurisdiction. This court sits in a position to review de novo. It can merely look at the ticket itself, and I would just ask the court to look at the numbers in a straight line.
But counsel, the state is emphasizing the fact that there was not just the numbers, but there's this narrative. And it may be just a situation where it's hard to read the officer's writing, but he was still obviously put on notice of the correct offenses.
Well, Your Honor, I understand what the court's saying, and that's almost identical, different charges to the scenario put before the Supreme Court. What Mr. Pajestka knows, what he's put on notice of, is entirely irrelevant. What matters only are the numbers on that document. That is the charging document. That's the charging instrument. And this sloppy handwriting is, like my 3rd grade teacher told me, sloppy handwriting is on me. It's not on anybody else. And here it's on the officer. And it was on the state of Ohio to look at their ticket and say, hey, is there any confusion here? Because I would say any person looking at this ticket objectively, there's a serious question as to what's there. I would say just looking at 4511, just the way in which he wrote the numbers, he has very distinct 1s and very distinct 2s. And I leave it to the court to review that. I did want to discuss a couple of things counsel said as it relates to the prosecutorial misconduct argument. It seemed to me that I heard the implication being that Mr. Carroll waited to find this video. If we look at transcript page 91, the trial court found that the video materialized that morning. So it wasn't something that Mr. Carroll below did. The trial court found that the video materialized, his exact words were materialized this morning. So it's not, because what had happened was the police report actually says that the video in question, and this is all in the transcript from 82 to page 91, the police report itself reads that this video that showed up didn't actually exist. So Mr. Carroll, the trial attorney, was put on notice that this video didn't exist. He requested it, and the second day of trial, according to how the state's calculating days, the prosecutor walked in and said, oh, hey, by the way, the video actually does exist. So that's a little bit different than Mr. Carroll sitting there not doing anything. And that would also implicate that this case had been set for trial 8 prior times, and the state of Ohio.
And counsel, I'm going to interrupt you just for a second to make sure, just the
Yes,
same
ma'am.
questions that I was asking the state. Everything that you're talking about, is that on the record?
Yes, Your Honor. If you look at transcript page 82, it's the transcript that is dated 813-20. It's going to be in the transcript 82 to 86 range. And then the materialized this morning quote that I'm giving the court, that's on transcript page 91. Also, when we talk about what's on the record, the prosecution admitted, as she's already said here, admitted to making the statement But from transcript pages 82 to 86, attorney Aaron Schwartz, an attorney of 18 years worth of practice, lays out the exact, in almost excruciating details, play by play, how the entire scenario went down. And that's obviously not under oath, but that's an officer of the court making a representation to the court. This is then followed up with Attorney Schwartz's under oath affidavit, which has not been contested in any form as to what exactly happened. And this is all part of the record. And here the threat was, if he testifies to the truth, he will be prosecuted.
Counsel, I know you have limited time, but I'm getting very confused. I thought the only affidavit in the record was from Attorney Caro.
That is the affidavit. I'm sorry. So Attorney Schwartz was on the record. Attorney Schwartz, because Attorney Caro in our position had become a witness at that point, Attorney Schwartz, who was sitting second chair, took over making the record. Subsequent to that, Attorney Caro, and I apologize if I was not clear, Attorney Caro then submitted the affidavit for what he personally saw and what he personally observed. And that was submitted as part of the motion to dismiss. So we have two parts. We had Attorney Schwartz on the record laying out step by step what had happened, and then Attorney Caro following up with an affidavit to what he personally saw and observed.
But Attorney Schwartz did not submit an affidavit and was not on, when I say on the record, in regard to evidentiary matters.
He was on
testify.
The record. He did not. No, he did not testify. He did not swear himself in or anything like that. It was a delicate situation, as this had just happened. They brought it onto the record immediately. And Schwartz handled the on the record part, because at that point, Attorney Caro had essentially become a witness to the matter that they're complaining of.
Counsel, I'm sorry, but you are out of your rebuttal time. So
that's probably a relief to everybody. Thank you, Your Honor.
I want to thank you both for your arguments today. You both did a very nice job. The court will take the matter under advisement and issue a written decision that will be mailed to both of you. And of course, the decisions are also posted on the Ohio Supreme Court's website. Again, thank you for the nice arguments and have a good day.
Thank you, Your Honors.
Thank you.
Thank you.